Okay, there is a tab where I can download the attendance. Okay, so make sure you don't simply drop out of our meeting in the middle. So you have to stay from the beginning till the end, because I'm gonna download the attendance list for those who have joined at the end of our session. And there is a record where when you start joining and when you start dropping out, or when when you end the conversation, so we can trace the record of your activities lah. Okay, all right. So how many participants are here now with us? Ana nak tengok ni. Sekejap ya. 40. Okay. Right. Saya nak cari kat mana dia cakap boleh download attendance. Let me upload the slide. Okay. I think we just proceed to topic 3 first, and then we do the revision later. Okay? Can you look at the slides? The slides, do they appear on your screen?
Yes, madam.
Boleh,
Yes.
Yes, madam.
Okay. I'm gonna play the slide. Right. So with KLB2, I have not actually touched on topic 3 yet. I have done topic 3 with KLB2. Okay. Our physical meeting before PKP. Yeah. So let's do this first, and then we come back to our revision later. Okay? So make sure your friends who have not joined us, tell them to do it now, because I'm going to start a lecture on this new topic, so they can catch up, okay, from the beginning. Yeah. Okay, now we are on authority of solicitors and its limits. So when we talk about the limits here, we want to know to what extent solicitors will have to carry out their duties towards their clients. What are the limits, and if they go beyond the limits, then what happens? Okay. Have we actually discussed about retainer? Have we discussed retainer before?
Not yet.
Yes, we forgot.
I think yes.
Tutorial, right? Anybody remembers what a retainer is? You can come off mute and explain to us. Anybody? In your own words, what do you understand by a retainer?
An agreement
Okay, between
a lawyer or advocate and client.
okay. Okay, that's I think that's that captures the essence of what a retainer is. An agreement between a lawyer and his client. Yeah, it's an execution of letter that creates legal consequences and relationships. It's a contractual relationship, and it carries, of course, legal implications. Okay, it sets out the duties, responsibilities of the lawyer towards the clients, and limits and what he must do and must not do. Okay? The solicitor-client relationship is actually similar to the principle, to the relationship between a principal and an agent. Okay, in essence, this is the nature of the relationship. All right. So in the case of Tyrrell and Bank of London, the issue was whether the solicitor has exceeded his authority to act on behalf of the client. And it was held that this depends very much on the terms and the scope of retainer. So retainer plays a very important role in determining the extent of authority for the lawyer to act, okay, for his client. In the second case, the solicitor's authority again depends on his retainer and is limited by any special condition imposed and supplemented by any special authority conferred by it. So it will be, the retainer will spell out the conditions and any special authority that the lawyer can that will form the ambit within which the lawyer can act for his client. All right, much of it stems from this retainer. Are you with me?
Yes, Doctor.
Is my voice clear?
Yes.
Clear, Doctor.
Okay. Okay. When we talk about representation for a client, it can be in contentious or non-contentious matters, and the authority. Okay, if you talk about retainer, normally it is written, but beyond retainer, you can also have authority by the client that is given orally or that can be implied. So other than the retainer, authorities for a lawyer to act for his client may also be in the form of verbal instructions and may also be implied by conduct and ratification by acquiescence secara tidak langsung. Indirectly you can imply, right? But you have to prove. If it goes to the court, then it may not be easy to prove the third one by implication. So the issue that arises here is, what if a client objects or varies the authorities contained in the retainer? Okay. For instance, if the client objects or does not agree to the counsel authority to compromise and withdraw the retainer and withdraw his retainer in the open court. Okay, what if the lawyer's action for his client, okay, he intended it to uh, to be carried out according to what the client wishes, but later his action is challenged by his own client. That is why, as a lawyer, you must go back to the retainer. Okay, you must always make sure that whatever you do as a lawyer, all right, falls within the limits of the retainer that you have signed with your client, right? But in short, you can actually discuss this issue in the light of, first, the authority to conclude a contract, the authority to compromise a lawsuit, and the authority to concede on point of law or on point of fact, which I will go through with you now. Yeah. Okay, another issue was whether the respondents had authorized in the case of Tae Yok Ki. The respondents had authorized the firm to conclude the contract in favor of the appellants. Right? In this case, the third, the third way in which you can imply the authority, was evident. It could be reasonably inferred from the evidence that the respondents had ratified the bargain. Okay. In this case, the firm's action in contracting on behalf of the appellant or in favor of the appellants was challenged by the appellant, and the evidence shows that it was clear from the evidence that the respondent had actually ratified the bargain. Okay. So the burden of proof on any party is on the party alleging the existence of the authority. In this case, the delay by the respondent to challenge the solicitor's authority was relevant to infer ratification and acquiescence. Sekiranya terdapat delay on the part of the client, for instance, to challenge what he disagrees or what he objects to, then the court tends to take the position that he has acquiesced ataupun he has ratified impliedly the action of the lawyer. Okay, so he is stopped from objecting to it or denying that he has approved the particular action of the lawyer. So let's see in detail contractual transactions in regards to the limits of authority. So you have express authority, which is needed, and not general authority for a solicitor to act as agent for his client. So in other words, the authority must be expressed. So you can actually see the case of Yo Get Lang and Alice Wee, which involved the purchase of landed property subject to a contract. In this case, it was contended by the purchaser that the authority has not been given to the solicitor to buy the property. In this case, the Singapore Court of Appeal held that the solicitors must obtain express authority to conclude a contract. So in matters involving contractual transactions, the law is quite strict in the sense that you have to obtain express authority. You cannot just imply the approval of your client, for you to do any purchasing transaction. In this case, there was no evidence that the appellant had authorized the solicitor to negotiate and conclude a bargain on the person's behalf. So ideally, there should be 3 solicitors in the case of conveyancing. A lawyer that acts for the vendor, for the purchaser, and for the financial institution, macam bank. So for each of these parties, to avoid conflict of interest, between the duty of disclosure and the duty of confidentiality, a lawyer cannot act for 2 clients or 3 clients at the same time. I thought I had actually expounded and explained about this in my lecture on duties of solicitors, right? So it would be a breach of a solicitor's duty to act for a bank and a vendor, or a bank and a purchaser at the same time, for instance. And of course, between a vendor and purchaser, you need to have separate lawyers in order to avoid conflict of interest, right? You're supposed to advise each party at one time. So in this case, the advocate and solicitor, being the defendant, acted for both the bank and the borrower, and they failed to register a charge in favor of the plaintiff. It was satisfied on the balance of probabilities that the defendant had breached the undertaking he gave to the plaintiff in his personal capacity. So this is also another limit, okay, to which you have to adhere as a lawyer. So what about implied authority? Can there be an implied authority in the case of a contractual transaction? Again, the case of Alice Wee just now, yeah, it was held that the payment of 10% deposit does not form an implied authority for a solicitor to conclude a contract for his client, right? So does it mean that the client has paid 10% in advance can be taken as the client giving the authority for the solicitor to proceed with the purchase. Okay, you need an express consent from the client for you to do the entire purchase. Okay, so Lockett and Norman Wright, 1925. The basis of the contract is subject to the drawing of a formal agreement. The payment of deposit does not give right to the authority to conclude a contract. So if a question comes up, okay, involving this kind of transaction, payment of deposit by a client, does it give an automatic right by implication, okay, for the lawyer to conduct the purchase on behalf of the client? So you have to cite all these cases as your authorities, okay? If you have more recent cases, that would be good, yeah? Okay. Now we move on to express authority in civil suit. The contractual transactions. Now, let's look at civil suits. So in the case of civil suits in Matthew and Munster, this is an English case. The court held that express authority is not needed if, okay, tengok balik kat situ, if it involves a matter which is in the ordinary authority of the council to act. Okay, so there is a proviso whereby if it is in the ordinary authority of the council to act, then the express authority may be done away with. You do not need this. Okay. Okay, in this case, Munster faced a suit of malicious prosecution. He was traveling to court by train. He was on a train when his barrister settled the case on terms adverse to him. Adverse means that he did not agree to. And then he applied to set aside the compromise agreement. Okay. Take a look at what Bowen LJ said here. Okay, let's take a moment to read through this portion of the judgment. And can I have somebody to explain to me what you understand by this part of the judgment here? Can I have somebody to share your thoughts on what this portion of this the judgment means? Maybe you can summarize in your own words. Should I call out names? Sekejap ya, let me see. Boleh saya panggil nama tak? Nur Aziah Faizmah. Ada di sini tak? Do you want to explain to us what you understand by this?
Sorry,
Aziah.
madam. Is what I can understand from this case briefly is that the issue is whether that counsel or the solicitor can be called an agent of the client.
Okay.
But whether that counsel has a particular authority to present the client on the court.
Okay, that's the first part. What's the second part about?
The second part
Okay,
is
let me call another person. Hamzah Ahmad Bashir. Hamzah Ahmad Bashir. Ada?
Yes.
Okay, what do you understand? Okay, in your own words, can you tell us what is the second part of the judgment about? The portion of the judgment that we put here about.
What I understand is when the counsel for the client can be called as an agent, and with regards that he have an authority to important matters in which the client has an interest, which means he can represent his client. If the client was not present, he has the command and authority to do best for his client.
Okay, that's quite what it is about actually. Okay, for the first part, it has been frequently debated and discussed whether we can call counsel as an agent for his client Okay, according to Bowen LJ, even if he is called an agent, okay, the agency is not an ordinary agency in the sense of what we understand between a principal and agent, because he has a further authority, which is explained in the second part. Okay, when it involves important matters in which the client has an interest. Okay, now this is what he meant by, okay, it goes beyond the ordinary sense of the agent and principal and agent relationship. Okay, whereby in the current case where the client was not present and cannot complete and was not present in matters that he has an important interest to it. Okay, so the lawyer or the counsel who is present therefore is in charge, and he has the command and authority to do best for his client. Okay, including to compromise the suit to achieve, for instance, an out-of-court agreement with the other party within the reasonable limits of his authority. So if it's within the reasonable limits, this is another proviso that you cannot simply leave out. Yeah, it doesn't mean that you have uh, the authority and the liberty to do whatever that you feel right, and whatever that you feel good about. You have to also come back to the limits of your authority. Okay, if it's too if it's too beyond what you are given, what you are allowed to do, for instance in the retainer, if it's clearly against the express provisions, for instance in the retainer, then you can still be challenged. Okay, but if it's still within the reasonable limits, then it should be okay. Yeah? Express authority in civil suit, again please read the Kahwa Bank Limited Nadinusa, okay, and other more recent judgments. Okay, so what is meant by ordinary authority include getting the next mentioned date or the hearing date. Entering a consent judgment is actually within the ordinary authority. Okay, unless there is a clear objection, okay, from your client, then you might be in trouble. Okay, so be careful. It's always prudent to get everything to be written down. Okay, sama ada secara official or through email. Okay, so that you can fall back to this written evidence that you have actually been given the authority to act on behalf of your client, right? Always get the consent and approval, all right? From time to time, get in touch with the client. Jangan buat sesuka hati lah. Ya. Even if compromise is entered into without the presence of the client is bound. Against not only limits, you also have to take into consideration the best interest of the client. Alright, all these vary from one case to another. Okay, it depends on the facts. When it goes to the court will evaluate all the provisos that we have come across before deciding on whether the lawyer has exceeded the authority or not. Okay, setakat ni, are you with me? Do you have anything to raise? Okay.
Okay, madam.
Alright. Okay. Can we proceed to the next slide?
Jadi mak tanya boleh?
Yes, yes.
How to determine whether the council has exceeded the limits of his authority?
Okay. What we have covered so far, we have looked at contractual transaction dengan
Civil.
civil suit, right?
Yes.
Okay, nanti kita tengok specifically compromising a lawsuit settlement nanti. But so far, I have actually explained to you where you can find the sources of the limits. As a lawyer, you have to know what are the sources of your limits to act for your client. First, we talk about the retainer. Betul tak? Retainer is the agreement between you and your client. Okay, when I say you, I mean you being the lawyer and your client. You have the agreement, the terms of reference or the TOR. Okay, what you should do, what is required for you to deliver in your service, etc. Okay, so that is spelled out in the retainer, which is in a written form. It's a contractual relationship that we can derive from this retainer. So you have to comply with what's been agreed by you and your client in the retainer. Itu pertama, okay? Untuk determine whether you have gone beyond the limit or not, you tengok apa terms of reference yang you dah bersetuju dengan client. Alright, second we talk about apa tadi? Okay, in matters, for instance, okay, after retainer, you can also look at the conduct of your client. Sama ada, you can imply that the client has actually approved of your transaction, action, or whatever duty you have discharged. Okay, macam case tadi ada satu case Take your key. Okay, the delay by the respondent to challenge the solicitor's authority was relevant to infer ratification, means to infer approval, okay, of the client, okay, um, of the action by the solicitor. Okay, ini adalah satu bentuk untuk menentukan sama ada solicitor tersebut masih okay dalam limits atau telah keluar daripada limit. So selain daripada written, you can imply, and the other one is to look at whether there is any oral approval given by your client. Selain daripada written and imply, you can also look at oral approval. Okay, secara verbally. Ini mesti melibatkan saksi lah. Kalau tidak ada written evidence, you have to bring witnesses to show that your client has verbally approved of what you have done. Yeah? Okay. Boleh so far?
Boleh.
Okay. Lain daripada tu, kita tengok subject matter. Sekiranya melibatkan contractuals, transactions, okay, maka kita tengok case law lah. Dalam Alice Wee tadi kena ada express authority. Alright, payment of deposit. Okay, tidak semestinya memberikan authority kepada solicitor untuk conduct the entire purchase. Alright, tidak boleh buat anggapan. Mesti ada express consent given. Alright, this is in the case of contractual transaction. Right? Sekiranya melibatkan civil suit, okay, tidak semestinya ada express authority. Okay, provided it is within the ordinary authority of a counsel to act. Apa maksud ordinary authority? Tengok case law, seperti untuk mencapai settlement out of court, okay, untuk agree dengan compensation, okay, to compromise, to achieve a compromise agreement. Ini adalah antara yang dikatakan sebagai within the ordinary authority of the counsel to act for his client. Dan kita tengok tadi the case of Matthew and Munster, what the judge said. Yeah? He is not simply an agent. He has a particular authority when it involves important matters in which the client has an interest. Okay, provided, mesti selalu as a lawyer, you cannot simply generalize everything. You must have caveats, provisos in your answers. That is, in this case, you have to pay regards to the limits of your authority. First, by looking at, for instance, the retainer, and also best interest, the concept of best interest. Okay, if your action has caused grave injustice, okay, to your client, then you cannot say that it is in the best interest, betul? So all this will be considered by the judge, okay, by the presiding judge. Yeah. Okay, let's look at the next slide on authority to compromise a lawsuit settlement. Right. So this one is usually will be followed by a consent judgment. Dalam bahasa Melayu apa ya? Perintah. Can somebody check what is consent judgment? In essence, what it means is judgment given by the court concerned to validate or to approve of your compromise that you have achieved between between you and the other solicitor, okay, on the other side. Okay, jika both solicitors have achieved a settlement, then you have to bring it to the court and you will have to apply for a consent judgment. Dan consent judgment terhadap settlement ini adalah binding. Okay, and you have to comply with the consent judgment. Sometimes there are cases whereby the consent judgment is later or subsequently challenged by your client. The client said that I do not want to comply with the consent judgment because I did not give my approval or consent to the settlement that you negotiated, right? So this is the issue that we're looking at now, yeah. Amicable resolution of litigation is regularly attempted by lawyers who are acutely aware of the limitations of the litigation process. So in order to avoid costly litigation and the time-consuming process, sometimes it's wise for both parties to achieve an out-of-court settlement. So normally, as clients, they leave the negotiation part with the lawyer to conduct, yeah, with the other party to achieve what is best for him, right? So normally the beginning of the process is by way of issuing a notice of demand or letter before action. Okay, lawyer for A will issue to the lawyer acting for B notice of demand that for instance your client pay to us this amount, okay, um, X amount of money as a settlement out of court, for instance, and then we'll see how the other party responds to the demand. So this is the usual process, okay. So it will normally encourage the other party to consider a settlement resulting in a compromise between the parties, right? So this kind of negotiation will require special skills, right? So lawyering skills is needed here. So you leave this one for the lawyer to negotiate, right? Which you expect to be producing a satisfactory settlement for both parties, a win-win solution. So the most common stages for consideration of settlement, bila? First, after close of pleadings, after you have done the pleadings, you can start negotiating. Okay, before the first case management meeting with the judge, okay, during any case management meeting, on the advice of the judge, kadang-kadang hakim sendiri akan menasihatkan supaya lebih baik isu ini diselesaikan di luar daripada proses mahkamah, okay, ataupun in the midst of the trial, tiba-tiba in the process of the trial, ongoing trial, both parties decide to actually settle this out of court, okay, for the best interest of both of them, ya. Dan selainnya you boleh baca ya, after judgment on the appeal pun boleh, during the hearing of the appeal, etc. Okay. So Swinfen and Lord Chelmsford, yeah, counsel is vested with a number of powers and obligations in the interest of the client to act with reasonable care, diligence and judgment and in the best interest. Always this will be the threshold of your duties towards your client. Alright, reasonable care, diligence, judgment, best interest. All these phrases, okay, will come in very significantly when we talk about professional negligence, misconduct dan sebagainya. Sama ada you have acted with reasonable care, okay, within the limits and in the best interest. Right? I hope you are with me. Right? So council shall discharge their duty to the best of their ability and that the barrister is immune from liability or has immunity if he has intended to act honestly and for the benefit of their client. Alright, nanti kita tengok secara lebih mendalam lagi bila kita masuk topik professional. Kita ada satu topik professional misconduct and disciplinary proceeding. Yang ni saya bercadang untuk invite practitioner dari luar untuk buat engagement dengan students. Kita akan set bila nanti. Okay, untuk liability juga kita mesti tengok topik duties of advocates and solicitors ya. Dalam tu selain daripada you tengok isu kita sentuh contempt of court dan sebagainya, di peringkat awal kita ada tengok juga the issue of liability for negligence sedikit ya. What is the legal position on that? Right. As a general rule, the compromise is binding on the client as also it is on the opposing party. Yeah? So your client should not be allowed to set it aside on the ground of public policy. In other words, if the court simply allows the agreed settlement achieved between the parties to be set aside by one of the parties, then it will be against public policy in the sense that it will discourage out of court settlement, okay, which is actually what is the best, okay, because litigation, as I said, will have a lot of consequences and implications in the short and the long term. So it's always best, okay, for the parties to achieve settlement through negotiation, okay, as compared to going through litigation. So this is the kind of public policy that our justice system tries to promote. All right, so if you simply allows settlement of court to be challenged on any ground, regardless, then it would discourage this promotion of public policy and that I mentioned. Yeah. Fray and Val, the council may only compromise an action under express instructions from the client. Okay, this is one of the earliest judgment, 1859. Yeah, it could be liable for the lawyer could be liable for damages if it is done without the instruction of the client. Okay. Tapi you can see the variation in the judgment. If you read local cases, solicitor can compromise a matter on behalf of the client provided it is done on a bona fide reason in the best interest and also in good faith. Ini satu lagi term, another term that actually form the limits around which or within which you may evaluate whether your action is still within the ambit of what has been agreed, or as within the ambit of your duty as a lawyer, or you have exceeded it. Bona fide means in good faith. Yeah. In Yap, Chi Meng and Ajinomoto, 1978, it was held that the court would be slow to review settlement agreement entered by solicitors to prevent the floodgates of disputes about the validity of settlement agreement, and because it would discourage out of court settlement, as I mentioned. This is the public policy by which the court operate lah, yeah. You give priority to settlement between the parties, yeah. So we do not want to open up the floodgates of all the challenges against the settlement, yeah. Case.
Doktor,
Yes.
yang settlement agreement tu maksud dia settlement di court ke?
Settlement between the parties, okay, you negotiate di luar mahkamah, kemudian you dah achieve apa yang you nak capai between the parties. Contohnya, the other party, you minta bayar pada klien you 500,000 sebagai compensation untuk accident, okay, between contohnya insurance companies ke. Bila dah settle, you bawa settlement tu kepada court untuk dapatkan consent judgment. Bila dah ada consent judgment, ia mengikat. So you don't have to go through litigation lah. Okay, so benda ni dibuat di luar mahkamah dan kemudian untuk menguatkuasakannya, to enforce the settlement, then you have to obtain a consent judgment. Alright? So boleh? Faham? Is it clear? Siapa yang tanya tadi?
Yes.
Yap, Chi Meng and Ajinomoto ni I think involve accident cases. Alright. There was evidence in the facts that the client actually gave approval to the solicitor to negotiate on his behalf, okay, as to the, I think, amount of compensation to be paid to him. I think he was injured in a workplace accident that caused him to be blinded, alright. So the court said in the absence of undue influence, fraud, mistake or misrepresentation by the lawyer or solicitor, the court would not allow the settlement to be set aside. Alright. Nanti ada a few cases and articles that I will upload onto your Microsoft Teams folder. You may go through, okay? Sebab pembacaan lanjut adalah penting. Okay, kita ada assessment berbentuk quiz dan juga take home nanti. So I hope you do your reading. Aside from the lectures, you have to do your homework as well. Yeah? So, but settlement out of court cannot be done on the basis of inequality of bargaining power. Contohnya ini mungkin berkait juga dengan undue influence dan sebagainya. Sekiranya you negotiate dengan client that is not represented by a solicitor, then there might be an issue of inequality of bargaining power, whereby one party has far more knowledge and skill to negotiate in comparison with the position of the other party, especially orang yang tak educated, not represented. So you cannot take advantage. So all this will be evaluated by the court when they want to determine whether the settlement has been done properly or not, according to all the thresholds and all the limits. Zainuddin and Exco 2001. Consent order cannot be varied unless it is with the agreement of the other party or parties affected by it. Okay, neither can a consent order be set aside unless the conditions are met. Sometimes you put conditions that the consent order will not be enforceable if, for instance, several conditions are breached, 1, 2, 3. Dalam keadaan tu, you bolehlah challenge, ya. But otherwise, it is generally binding on the parties, right? T. Devendran, Kerajaan Negeri Johor, application was made to set aside a consent order, in this case, the consent order on the grounds that the council had no authority. It was held. Once sealed, a consent order cannot be set aside at first instance in the original action. Okay, in this more procedural, you want to set aside, it must be set aside in a fresh action. You have to file for another action, right? So this is more procedural. Okay, apa pusing tu? Ada yang confused tu? Ada nak tanya soalan? Okay. In the case of Maria Chia Suklan, the client in this case alleged that she did not consent to orders being made in respect of 2 of her properties to be sold by a bank, okay, in order to enforce guarantees given by her, ya. So dia kata dia tidak bagi any instruction, okay, supaya hartanya dijual, okay, following his ni mungkin case mortgage, ya, failure of this person to fulfill her guarantee, ya. The solicitor gave evidence that the client personally instructed him, okay, after which he entered into a correspondence with the bank and concluded an agreement of compromise. The correspondence which was produced did not actually contain any reference to a consent judgment, but the trial judge accepted the evidence of the solicitor and upheld the consent judgment because there was no evidence of instructions to the contrary. Tidak semestinya perkataan consent judgment mesti ada dalam instruction by your client, according to the trial judge, so long as tidak ada arahan to the contrary, tidak ada instructions to the contrary, okay, not to enter into the consent judgment or not to do something against consent judgment, then in general you can say that the client has agreed, okay, has agreed to it, yeah. And further finding was made that the client was actually not a credible witness. So there are several grounds on which you can challenge a consent judgment entered into by your lawyer. For instance, when there was a mistake in drawing up the order that was entered into, there was an error in expressing the intention of the manifest intention of the court or the parties. The absence of consent was also held as an exception. Maksudnya bila tidak ada express consent dan perkara-perkara implied conduct juga tidak menyokong bahawa klien telah bersetuju, then you can challenge even if there's the lack of consent was unknown to the other side. The court had the power to interfere with such a consent where grave injustice would be caused by allowing the consent to remain. In other words, if there's grave injustice, okay, occur that possibly taking place as a result of the lack of consent, the court can interfere regardless or not this is known to the other side, right? Alright, can we take a 2-minute break sekejap? Then kita continue dengan the rest of the slides. Okay, kalau ada soalan boleh tanya sementara kita break ni.
Doktor,
Yes.
consent judgment tu, saya faham consent tu maksud dia klien bersetuju dalam retainer. Tapi judgment tu maksudnya, consent judgment tu maksudnya apa yang dah selepas dibawa ke trial ke macam mana? Kenapa ada word judgment tu?
Dia kena ada satu, you have to file an action untuk apply for a consent judgment. Maksudnya ni, maybe you nak buat perkara ni selepas trial telah bermula or maybe semasa case management bila you tengah bertukar-tukar dokumen ya dengan you pernah buat mooting tak? You kan ada satu proses di mana you akan tukar-tukar bundle of documents between each party, right? So in the preparation, okay, in the preparation towards your trial, you boleh achieve agreement di luar mahkamah. Tapi you nak enforce benda tu. You nak enforce. Agreement tu you nak jadi enforceable, binding. So you kena apply satu consent judgment daripada mahkamah.
Okay, faham.
Dia dua perkara yang berlainan. Retainer adalah apa yang telah dipersetujui oleh lawyer dan klien. Macam TOR lah, macam saya latih awak untuk buat kerja A, B, C, D. Okay, you kena siapkan dalam tempoh 2 tahun. Okay, you kena buat dengan syarat-syarat ini yang bertulis agreement. Dia adalah standard punya terms kecuali ada persetujuan selanjutnya yang dibuat, you boleh letak ya persetujuan selanjutnya itu dalam you punya retainer ya. So boleh tengok S. Pakianaden and R.K. Stellet dengan Master M. Masden untuk contoh cases di mana the court agreed to set aside settlement, the settlement between the parties on the ground of grave injustice. Ya, grave injustice, sesuatu yang of course not in the best interest. Not only that, it causes maybe losses or injuries to the party as a result of the settlement. Yeah. Take a look at this case. Okay. This one involves Sean Delamore. If you know, this is quite an established firm in KL. Yeah. Medot Trading and Vijay Kumar. In this case, appeal was made by this firm, Sean Delamore. Following that, the firm shall bear the cost of the action. In this case, Medot Trading initially hired another firm to represent them. Kemudian selepas itu dia this Medot Trading appointed Sean Delamore. Yeah. The action was taken over by Sean Delamore in 1993. Okay, the previous firm hired had put up a claim for legal fees of 500k, and this was disputed. Yeah. So Sean Delamore filed action for the client. The previous firm challenged the authority of Sean Delamore. They requested the production of a resolution of the petitioners board of directors, Medot Trading, that they had actually authorized the firm, Sean Delamore, to act on their behalf. There was no response given. No such resolution was given as well. And by virtue of rules of High Court, Order 59, Rule 8, Lemma was held to be personally liable to pay the cost of this action for acting without due authorization. Okay. Kalau nak faham kena baca the full case lah. Ya. Dot trading it involve the challenge against Lemma for acting without authority. Okay. There was nothing that dot trading could produce, yeah, to show that Lemma had the authority to act on their behalf, yeah. Authority to concede a point of law or on a point of fact. Ini juga menjadi issue when it comes to challenging the limits, yeah. So if a lawyer makes a mistake on concession of a point of law, okay, if he concedes on a point of law by mistake, it can be withdrawn during the case or at appeal, during the appeal process. But for point of fact, it is more serious if it concedes on point of fact by mistake and the other party has relied on it, then no withdrawal is allowed. Ingat principle of estoppel, ya. Kalau the other party has acted in reliance of this the fact that you have presented, okay, secara salah, maka you're not allowed to retract, ya. Dan you may be liable for negligence or misconduct dan sebagainya sekiranya perkara itu dicabar oleh your client, ya. So boleh tengok cases ni selanjutnya. Untuk tutorial questions, tajuk ni ada 3. Okay. Saya ada pesan, ya, untuk evaluation, minta tolong setiap TLB membuat slide presentation, okay, dan akan ada markah untuk slide presentation yang kemas, teratur, ada case dan sebagainya yang bagus, ya, dan juga presentation secara verbal. Kalau boleh stick to your group untuk submission ni. Masa you present mungkin tak semua orang, ya, tetapi untuk submission minta tolong nama semua dalam TLB ada supaya markah untuk semua juga ada nanti, dan saya akan combine oral dan juga written slide presentation. Okay. Untuk akan datang kita kena aturkan bila you nak present, okay. Bila you nak present satu, dan kemudiannya cara you nak present. So bila you nak submit, saya minta tolong kalau boleh ada voice over supaya kalau you tak sempat present or for any reason, kita ada voice over. You boleh guna power PPT biasa, you boleh record your voice as you play the slide, ada background voice to explain. So saya boleh bagi markah tu. Tapi untuk discussion, kita bolehlah minta you present live lah macam saya buat sekarang ni. Okay. Ada soalan tak?
Doktor, yang tutorial question tu kan ada 3 soalan. Sekarang ni kita orang ada 4 TLB, so maksudnya satu soalan lagi macam nak buat macam mana?
Maksudnya ada 2 TLB akan buat soalan sama lah, tapi tak boleh tiru lah.
Oh, okay. So kita orang decide sendiri ke macam mana?
Boleh decide sendiri.
Okay.
Boleh ke?
Boleh.
Ya. Okay, untuk tutorial, you nak buat grup-grup kecil macam hari tu ataupun you boleh buat macam, saya rasa lecture saya ni tinggal 1 lagi je kot. Kemudian kita boleh proceed dengan apa ni, pihak practitioner luar. untuk live dengan you all. Saya cuba aturkan lah 22 hari bulan ni mark dalam kalender, insyaAllah ada engagement dengan Hakim Mahkamah Session Sepang. Okay, dia nak bercakap pasal ethics in court. Dia kawan baik saya, dia setujulah so far. So dia nak buat tu pada 22 Jun hari apa? Boleh tengok tak? Saya harap semua, saya nak gabung ni supaya semua boleh hadir.
Hari Isnin.
Hari Isnin, madam.
Isnin pukul 11 ke 12 boleh tak? All boleh tak?
Kelas.
KLB 2 ada kelas sampai pukul 12.
Alamak, iya ke? Saya ingatkan time tu free semua. Jadi time free ni berapa? Sebab saya nak kena bagi tahu dia punya jadual ni agak susah nak match dengan kita, dia hakim kan. So dia ada hearing dan sebagainya. Pukul 12 ke 1 boleh?
Boleh kot.
Boleh madam.
Boleh.
12 ke 1 kan saya tukar sikit lah. Hari tu saya cakap 11 ke 12. Sebab Syahmi bagi tahu macam okey 12 ke 1, 22 Jun ya. Okay. So saya minta you baca topik-topik dengan topik untuk kita discuss dengan practitioner luar, sediakan soalan supaya ada two-way engagement macam kita buat sekarang lah. Ya. Dan selepas untuk topik-topik yang ada engagement dengan pihak luar, mostly saya akan minta you all buat, you all jawab quiz nanti. That means you have to study in advance. Dan make sure you take note properly semasa engagement tu, dan soalan saya akan design based on engagement dengan practitioner tu lah. Kalau ikutkan course outline yang asal kan, you all kena buat simulation lah dan sebagainya. Sekarang dah tak boleh buat dan kita terpaksa adjust apa yang terbaik dalam konteks online learning lah. Okay. Untuk next, besok saya nak set meeting untuk topik keempat bersama dengan KLB1. Pukul berapa yang semua orang available? Saya rasa Syahmi dah set hari tu kan? Hari Khamis. Betul tak?
Yang set hari ni Khamis pukul 2 sampai 4.
Okay. So besok Khamis, besok 4 hari bulan kan? 4 Jun 2 sehingga 4 saya buat topik 4. Okay, topik 4 ni adalah berkenaan dengan privileges of advocate and solicitors ya. Privileges. Okay. So you punya presentation ni sebenarnya saya nak you buat sampai extent of counsel's authority ni je. Yang lain tu saya akan buat quiz, lain tu saya buat tugasan bertulis untuk you all, dan video macam kita buat last year tu, video presentation yang tu untuk saya allocate about 10 marks kat situ. Penyediaan tugasan video mengenai topik secara berkumpulan. Okay. Saya belum aturkan lagi bila kena buat dan sebagainya. Ini saya just perancangan saya dengan pihak fakulti dan mereka sedang menilai kaedah yang saya guna untuk online learning ni. Kalau diorang kata tidak ada masalah, dan saya akan bagikan tugas tu kepada you all lah nanti. Okay. So kita ada dalam sampai bulan 8 kan? Berakhirnya extended semester ni, betul tak?
Betul.
Betul kan? So dalam bulan 6 dengan bulan 7 ni kita cuba buat assessment secara berkumpulan. Untuk quiz dengan take home akan secara individu lah. So about 50% berkumpulan, 50% individu. Lebih kurang macam tu lah. So yang saya duduk suruh you buat slide tu masuk bawah berkumpulan lah. Tugasan bertulis berkumpulan juga. Video pun berkumpulan. Jelas ke?
Jelas.
Jelas.
Ah, okay. Kejap saya nak panggil satu-satu sebab saya takut tak boleh nak download attendance. Saya belum mahir lagi. Muhammad Luqman Al-Hakim, kalau ada angkat tangan dan tulis dan cakap ya, yes. Muhammad Luqman Al-Hakim.
Yes, ada
Okay.
madam.
Alright. Muhammad Fakir Razi.
Saya ada madam, Fakrul Aziz.
Alright. Nur Sabrina Huda. Nur Sabrina Huda. Nur Sabrina ada ke Nur Sabrina? Tak nampak tangan, tak angkat. Ada orang boleh check. Ada tak Nur Sabrina ni? Takut dia tak boleh nak ni. Tak boleh.
Sabrina.
Tak ada.
Sabrina.
Nah, betul.
Oh, okey. Apa kita proceed dengan Muhammad Fadil? Muhammad Fadil.
Fadil.
Angkat tangan.
Oh, Fadil.
Tangan virtual, bukan tangan betul. Tangan virtual tu. Nampak tak? Dia tangan virtual tu kan. Husna.
Ya, saya ada.
Okey, Umi Alia. Alright, nampak. Alia. Tak nampak Alia ni. Tak ada. Nur Ainina. Okey, nampak.
Aku tengah serabut ni.
Nur Azira.
Sana.
Nur Azira ada.
Kak pun bukan.
Hamzah.
Sekejap aku buat.
Bukan Nazira. Hamzah
Saya.
ada, Nazira ada.
Saya.
Ada. Nasuha. Ada. Siti Mariam. Ada. Nur Arifah. Okey. Eliana Syakir. Ada. Muhammad Asudin. Muhammad Haruddin. Tak ada Raya.
Madam, ada.
Mungkin ada
Lagi.
Raya Nur Sakina ada. Okey.
Ada madam, saya. Ada madam.
Okey. Elisa Hanis.
Ada madam, ada.
Umi Umairah. Nur Atikah. Okey. Siti Aisyah.
Saya, madam, saya.
Nuri Sufia. Okey. Syauki Mardiah.
Saya ada
Alright.
madam, saya ada.
Okey. Ashraf Abu Bakar. Alright. Muhammad Faiz Hakim.
Saya ada madam.
Alright. Nur Aziah ada. Narisha Nurhida. Alright. Nur Najla. Ada. Muhammad Faiz Ashraf. Wan Auni ada tak? Wan Auni.
Ada madam, ada.
Raudatul. Muhammad Hadri. Tak ada. Norisha Juliana. Ada Siti Nur Arifiah. Ada Muhammad Syahir. Ada Muhammad Riyasuddin.
Saya, madam, saya.
Okey, Nurul Adila.
Ada madam.
Nur Syakirah. Wan Muhammad Muizuddin.
Ada madam, ada.
Wan Siti Khadijah. Tuan Fatim. Okey. Wan Nur Atirah.
Ada madam.
Wan Nasrin.
Ada madam.
Angkat tangan tahu takut suara orang lain. Angkat tangan.
Saya tak pakai tudung madam.
Orang suruh angkat tangan bukan suruh on camera.
Berjut angkat tangan.
Tahu tak nak angkat tangan?
Macam mana? Saya tak hati.
Klik kat situ, klik kat tangan
nampak
tu.
tak tangan tu.
Sumpah tak hati mana.
Dia on pakai handphone tak tahu ada ke tak. Wan Nasrin.
Ya saya.
Oh, pakai handphone. Siti Nadia. Okey, Nur Kamila.
Saya madam.
Azman. Okey, Wan Nur Nasifah. Alright, Fitriah Radika. Okey, tinggal beberapa orang je lagi tadi. Sekali lagi Nur Sabrina Huda. Nur Sabrina Huda.
Saya ada madam.
Angkat tangan boleh? Tak tahu suara siapa tu.
Dah angkat dah.
Dah angkat dah. Fitriah, okey dah. Muhammad Fadil. Angkat tangan Muhammad Fadil. Tak nampak Muhammad Fadil tak ada pun.
Ya.
Dia tu siapa? Muhammad Fadil.
Saya.
Angkat tangan. Tekan dekat tangan tu. Press on the tangan tu. Klik kat tangan.
Angkat tangan aku.
Okay. Siti Nur Arifiah.
Ada madam, ada.
Alia
Ada.
Abdul Jalil. Last Alia Abdul Jalil ada. Alia Abdul Jalil. Tak ada. So bagus ya kehadiran lagi memberansangkan ni daripada physical lecture. So saya harap next punya meetings pun macam ni juga kehadirannya. Okay. Cuma kalau boleh prepare lah, jangan bangun tidur terus on camera, tak gosok gigi semua. Okay. Nanti it affects your focus ya. Make sure berada dalam keadaan yang sober, waras dan bersedia. Okay. Kalau boleh bacalah sikit topik-topik tu. Saya akan upload beberapa artikel. Please baca apa yang saya akan upload nanti. Okay. Daripada apa yang saya share, nanti saya mungkin keluarkan soalan selain daripada slide lecture dan apa bahan-bahan lain tu yang saya nak upload nanti. Kemungkinan saya akan keluarkan dalam kuis ke, dalam take home ke, tengoklah nanti. Alright? Okay, untuk slide revision tu saya akan upload. You tengok je nanti. Kalau ada soalan nanti you tanya kita punya next meeting. Boleh? Saya upload nanti. Saya rasa ada recorded dekat dalam kita punya group ni. Kalau you rajin tu you tengoklah. Boleh revise sikit ya. Okay, untuk presentation slide ketiga ni boleh tak you prepare dalam minggu ni, minggu depan you standby mana-mana group yang ni saya panggil untuk present live. Okay. boleh buat recorded audio. Tapi bila nak present tu, save lah yang tak ada recorded. Untuk submit nanti ada recorded. Boleh? Mana-mana yang saya nak panggil untuk present, saya panggil. Yang lain saya akan bagi evaluation lah. Ikut apa yang you submit. Boleh?
Boleh.
Boleh. Ini yang topik yang ni madam?
Topik yang ketiga. Yang
Okey.
topik yang kedua, ada lagi tak yang tak present? Berapa ramai lagi ya?
Topik 2 rasanya semua dah.
Boleh madam.
Sekejap ya, saya cuba tengok yang Syahmi bagi kumpulan hari tu. Nampak tak yang saya display ni?
Nampak.
Nampak madam.
Saya dah pesan TLB 3, TLB 5 minta tolong submit ya. Kemudian tajuk ke topik 2 yang saya merah-merah tu sepatutnya ada question yang TLB 5 tak present lagi, tapi boleh buat submission tu. Jangan lupa hantar kalau boleh sebelum minggu hadapan lah, sebab minggu hadapan kita nak tengok topik 3. TLB 5 ada tak wakil dia kat sini?
Ada.
Siapa?
Ada madam.
Ada.
Saya ingatkan nak present pada hari ni, tapi tak apalah, macam saya dah penat lah. Boleh tak you buat voice recording sekali dengan slide? Okay.
Boleh madam.
Next nanti kalau kita ada masa, ingatkan saya, kita boleh discuss sikit. Soalan 2 ni berkaitan dengan apa, you ingat tak?
Pasal duty of the advocate and solicitor.
Specifically apa? Contempt ke apa?
Misconduct and all that.
Duty. Okay.
Duty.
Boleh juga nanti kita dengar you present sikit. Tolong ingatkan saya bila kita buat dengan KLB 2. Okay, presentation sahaja. Kita habiskan dululah yang lecture-lecture ni. Nanti kita present lah. You prepare, make sure you prepare bila saya nak start buat presentation, saya nak panggil, you ada bahan dah ya. Dan you dah siapkanlah. Right. Untuk topik seterusnya kita discuss next week, insyaAllah, ingatkan ya. Ingatkan untuk topik 3 dan selanjutnya lah. Alright, tu sahaja untuk meeting kita, kecuali you ada apa-apa persoalan nak bincang atau nak tanya. Ada lagi? Apa dia?
Madam, yang berkenaan dengan presentation video tu, boleh madam consider cara lain tak? Sebab time PKP ni untuk kita orang discuss dan record video tu, dia punya cara tu susah sikit lah madam.
Tak payah muka you pun buat video macam apa you pakai apa hari tu. You tak payah.
Suara saja lah.
Boleh guna apps je.
Suara dengan slide.
Suara dan slide sahaja.
Ya.
Lain sikit daripada slide lah, macam video sikit, faham?
Pautun?
Yang tu pautun ataupun macam ala-ala YouTube pun boleh.
Okey, baik madam.
YouTube pun boleh juga. Boleh?
Boleh insyaAllah. Kalau macam tu akan diusahakan.
Alright, saya cuba nak download attendance. Okay, in the meantime you can explore Teams ni ya, penggunaan dia dan sebagainya, which is I think important dah di dalam fasa apa dia panggil norma baru ya. So make sure you are familiar with the usage. Saya tak boleh untuk goals pun saya terpaksa guna juga because goals tu lebih kepada kita punya macam submission, kalau boleh kat situ kot sebab ada markah penggunaan goals untuk lecturers ya. So kita tak boleh nak just ignore goals teruslah. So Teams ni lebih kepada meeting kita. Bahan saya cuba share dekat dua-dua medium ya. Kalau tak, okay, ada apa-apa lagi sebelum kita bersurai?
Madam.
Ya.
Saya punya TLB, ABJ tadi dia ada tapi dia cakap orang tak dengar.
Apa dia? Tak dengar?
Dia cakap, tadi dia sebut dah dia ada tapi madam tak dengar.
Nama
Semua
apa?
tak dengar lah. Alia.
Okay, Ali ada alright. Alhamdulillah penuh kita punya attendance je. Jarang-jarang berlaku, right? So norma baru ni kira membawa hikmah jugalah kan. Semua orang boleh hadir, duduk atas katil dan sebagainya. Alright. So thank you for making it today. Kalau ada apa-apa tulislah dekat chat pin dekat grup kita tu ya.
Okay, baik madam.
If you need to talk to me, you WhatsApp, nanti kita call. Saya lebih suka call lah sebab bila tulis ni faham dia lain. Alright. Thank you and we'll see you tomorrow, okay?
Okay, thank you.
Okay, madam. Thank you.
Madam, thank you.